rights and wrongs of the others. We are just to say, in terms of will drafting, what will be the best way to do it? So that is the challenge faced by us. Now, one thing you guys remember, I've just told you at the start of this lecture by saying that how you should prepare a simple will on urgent critical cases. But then there are other situations. A lot of people will make different wills. They will make different wills. They will make different wills free of charge, without paying any fees. And what is no good these days? Online in Hong Kong, you can get wills free of charge. The same applies to the United States of America. I have seen a lot of people, make wills in the United States. They got complicated tax structure, but their will is something so funny. What you do is just like going to Hong Kong, a local stationery shop, and then you buy something of a will, standardized will, and they come in as a package. They have what we call the living trust, and power of attorney, and all kinds of funny things all comes in as a will, in fact comprised of different elements of documents. And I've seen so many overseas Chinese, they got this very cheap. They do it at home, and then they fill in their name. That's it. How many of them would understand them? We don't know. My conclusion is that they don't know what they're doing. Even those people assisting them, they got a tax advisor, they got lawyers, and all this over 100 pages, put their name. The usual stuff is that in the United States of America, they will say, when I die, I give everything to the Wong Family Trust. Okay? Everything will go to the Wong Family Trust. My name is Wong. Okay? So go to the Wong Family Trust, and then there are all kinds of standard discretion. And put the name at the signing page. That's it. The problem is, I have personally seen that there's no trust. There is a living trust. There is a living, what they call the living trust. In fact, the living trust is something like a will. Something is called living trust, and then there's a will, and then there is another family trust. All of this are non-existent. They put their name there. No family trust form. What can they do? They better die without any assets. Unfortunately, they die and they have some assets. That's the problem. The thing that we have to bear in mind when you prepare a will like this these days, sometimes your client will come to you and say that, well, I want to make a will limited to my property in Hong Kong. Very common, they have a limited will. So all this will apply. But there is a problem. You don't know whether there is a general will covering all the assets, and whether there are other limited wills. One limited to my property in Melbourne, one limited to my property in Hong Kong, and then these guys are having all kinds of property worldwide, particularly across the border. In this past 10 years, I've seen people, having all kinds of property in mainland China. They find it very difficult to deal with the community property problem issue in the mainland. The same applies to the problem in the United States of America. So all this, in order that we will not fall into the same trap, one very simple thing you have to ask very clearly is, well, have you made a general will already? Or how many wills have you made before? The thing for us to remember is, will one, will make at day one, will usually revoke by will make at day two. Sometimes they will make will 1 and will 2 at the same date. Okay, one about all my property in Kowloon, the other all my property in Shenzhen. They don't realize this. That is why where we have the domicile comes in. My domicile is let's say Hong Kong. So the domicilian will probably prevail when it comes to grant, when it comes to interpretation. But the thing is, if there are two wills appearing at the same date without knowing which time it is, which prevail? Which is the will one and which is the will two? So if both will coexist at the same time, then it depends on the wording. In particular, revocation clause. If you make a will, the revocation clause, I make my will, I revoke all my property, all my previous will made before this. You better make sure, let's say this is a limited will. You better make sure that you sign the limited will together with the general, see which one will prevail. Now, if you make a general will, I make my will and I give everything to my wife and I appoint her to the sole executrix, full stop. This is general will, very simple, one page. And then I make another will. I now make this particular will. I make a will in Hong Kong. I give my house in Shenzhen to my boyfriend. There may be revocation clause. There may be no revocation clause. But the thing is, to what extent between the general will and the limited will, which shall prevail? It will then be your job to make sure, if you're doing something at this juncture, make sure you enter a time in your own file. 1 o'clock, make the general will. 1:15, make the specific will. Now the sequence will be, the day 2 will shall revoke the day 1 will. But if the day 2 will comes in, which does not apply to all the estate, then the day 1 will shall be valid except in so far as being superseded by the day 2 will, or when there is a general revocation clause in the day 2 will. This is where the argument comes in. This is where you guys, as a will preparation staff, will be liable. Because if you overlook the effect of the revocation clause, you make a day 2 will, limited, and yet people can argue this revocation clause in the day 2 will is not as limited as it appears to be. It has the power to revoke all the will made before. Then this is a problem. So all this, I'm drawing your attention in order to forewarn you in your future practice. When it comes to more than one will, be very, very careful. Okay? So this is something you have to bear in mind. Homemade will begin with what is most important and then other less important. So we make a will, we always have, of this standard practice. That's why I would like to train you guys to have this concept of common clauses. Common clauses. If you have all the common clauses in mind, then the chances are there will be a fair direction in the will. So you know that these are the various components. Something is missing, then you have to be very careful. So this is why in previous examination, in previous questions examination, I have set out the common clauses, asked students to recite. Not difficult, but it's just a reminder to us as will preparer to know that it's much better to have a fundamental systematic stages of the various clauses there, and you know what are the essential clauses, what are clauses which are only discretionary. Once you draw the distinction, the chances are you should be able to make a valid will in most of the circumstances. Okay. This is the first sample will I give to the class. This is what's called a universal legatee. Now, on this will, I'm now introducing you to the various jargons in the will, and in this case, legatee. Legatee is a beneficiary. But the problem is always confusing. It's always confusing because if you look at Rule 19, then you know that there are legatee and there are devicee. Okay? Legatee, devicee, they both means beneficiary. Legatee is gift of movable assets. Devicee is gift of immovable assets. Look at this one. Now, this will, you give everything to a beneficiary. So, the name, testator, identification numbers, address, and then also with the revocation clause, all appear in the same first paragraph. You may say this is optional. In fact, if you want to make it as simple as possible, there's no formality required in terms of the contents. You can simply say, I, Tek Wong, revoke all previous will. I give everything to my wife, and I appoint her the executor, full stop. You don't need no other clauses, because there is the testamentary intention. All I need is that it is in writing, my signature, and I ask two other people to be the attesting witnesses. This will be a valid will according to Section 5 of Section 1. Here you can see I give all my real and personal property, whatsoever and wheresoever. So that in fact simply means I give everything. If you're in a hurry, I give everything to my wife. That will be the same meaning. But then in making will, remember, if you decide to pick on the precedent, follow precedent, you have to follow those standard words in order to avoid making mistakes. Don't create words yourself. Like for example, real and personal property. In Hong Kong, this term has created lots of problem. Lots of problem. Because if you have the chance to look at the precedent on real, particularly those originated from the UK, then you say, my real property and my personal property, and then in UK law they have the real property and also the personality, and then they will have the real property and the leasehold property. All kinds of fine and funny distinctions that originated in 1925. The problem with us in Hong Kong before 1997 is Hong Kong, the only real property of freehold is the St. John's Cathedral. All other landed property are leasehold because it's a colony, borrowed for a time. Okay, all are leasehold. If all are leasehold, by definition, they are all personality. Personality may not be personal property. That's the problem. So if you're trying to be smart and create, words from one person to another person, the chances are you may fall into all kinds of traps. So one thing, just copy this. Okay, real property. Oh, in Hong Kong, what we mean real property is immovable property. Personal property, movable property. So in modern times, we will say I give all my immovable property and movable property. This kind of clumsy, but people use it. But if this is a universal legatee, then you can say, I give all my property. That will be done. You don't have to define them, all my property. Well, it may be property, real property, immovable property, personal property, movable property, or better still, we have a case in Hong Kong that's in fighting, the TAN case, TAN. Fighting because it is a will in Chinese. It has been fighting to the Court of Appeal. I give all property under my name to blah 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 in Chinese. 我給我名下的所有財產 and they go on. And simply because of this, the property in my name or the property under my name, the argument is fighting on this translation. But anyway, the undisputed part is it the case that this will is only giving the asset which is in the name of the testator? There was a big argument. Well, you say that it's property in the name of Ted Wong, but that in fact I have property held by my son as my trustee. The property is held in his name on trust for me. If in his name on trust for me, that means this is not a property in my name. So it was argue and fight very bitterly to say that, well, that being the case, the property held by my son is not covered by this will. Because the wordings in Chinese are so clear. You have limited the disposition to the property in your name. And now these are property not in your name. How can you argue away? So this case was argued eventually. It was argued and accepted by the court that, in Chinese, we Chinese, when we say property in my name shall include property actually in my name and also beneficially owned by me, albeit registered in third parties. They were so argued and finally accepted by the Court of Appeal because they managed to find from a dictionary to say that, Chinese talk about property in your name, in fact include two things. Number one, actually in your name. Number two, name property beneficially owned by you. So it was an extended argument. All right? So the thing is, so therefore you want to do this, the thing that I ask you, you may copy everything. The easiest way to make problem is you try to change it a little bit. That this is the time that you will add in order to create something which does not stand alone. If you don't change no wordings, just change the name, okay. You give everything to your wife. Then the only thing that I need to look at, when you die, who is your wife? Or do you have a wife? Once that is determined, no problem. Other than that, we talk about the testamentary intentions. But the meaning is clear. You see here, appoint her sole executrix. Now, I give all my property to my wife. This is a give clause. And appoint her my executor. This is appointment clause. So, if suddenly you prepare a will like this, and the testator says, hey, wait a minute, I want to appoint my wife and also my son as the executors. Then in a will like this, wordings like this, format like this, you create all kinds of problems. And then because they're paying for making a will, then they will say, hey, Mr. Wong, I want to change. I want to give to my wife and also to my mother. So you expand it to my wife and mother. Then the problem will come and appoint her. All kinds of confusion will come. will come in. So, the lesson to be drawn in a simple case like this is, if instruction is very clear, all gives to one person as beneficiary as well as executor, use this. Any amendments, any riders, don't use it. This will create more problems than you can solve, because you are making something out without knowing the exact legal effect. And if something turns sour, you'll be held liable, because you have used a very bad precedent. That's the attention that I like to draw you to. Okay? So this will is only possible when sole beneficiary as well as sole executor. Okay? Other than that, never use it. Never use it. Here, this is the common rule clauses. This comes out as examination questions several times before, for the reason that I like you to draw and train yourself more systematically. On the left-hand side, I have compiled 7 clauses, which we'll explain in detail as we move along. These are commonly used. In fact, there's no law to say that these are the only common clauses. You can always argue. Okay? You can say there are 8, 9, 10, or 11, or there are only 1 or 2. It's up to you if you can argue. So anyway, this is only cited as an example to show you briefly what are the essential parts to cover the formality requirement, as well as a part of the will in order to support any challenge on testamentary intention. The thing that I need you to remember is burial, domicile, investment. For this purpose, they are not essential. They are not a must. They are not a must. Particularly on the domicile clause. Domicile is a very difficult concept and is capable of changing all the time. It's not a matter directly on the holding of your passport, your ID card, your driver's license, or whatever. No. Domicile is an old term that talks about a person having lived in a place either permanently or indefinitely with the necessary intention. There is no rule to say that living here for 3 years, then this is long enough, or below 3 years is not enough. No. All boils down to your intention. That's why for this purpose, you may have the domestic maid working here in Hong Kong in your family for 10 years. But they come here from the Philippines only for the purpose of employment, or predominantly they come here on a working visa. So this is not their domicile. This is only their place of work. And therefore you cannot argue this is the domicile. So if you have a will from a Filipino maid to make a will, the best bet, exclude the domicile clause. Who knows what her domicile will be when she died? And there's no law that requires you to give a domicile when she makes a will. So the best bet, avoid it. Similar arguments shall apply to whoever that comes in from across the border, as well as those from overseas. If you're dealing with a will from people coming from North America, well, it's very difficult, particularly when we know that domicile is something on a place, not on a country. In Australia, by the state. Canada, by the state or province. United States, by the state. So it would be wrong for you to say that, I have made a will then the testator died domicile in the United States of America. That is utterly wrong. There is no such thing as a domicile of the United States of America. You can say, all right, it's domicile from the state of California, that's okay. The same applies to the United Kingdom. Domicile in Scotland, okay. Northern Ireland, okay. You don't have a domicile of United Kingdom. The rationale is there are different personal law that governs. So like in Hong Kong, domicile in Hong Kong, domicile in Macau, domicile in Taiwan, and domicile in the mainland. Sometimes I have seen people say, oh, people die domicile in PRC. This is a very difficult concept because traditionally we have been accepting that within PRC, at least we have the 4 different jurisdictions in terms of the personal law because of historical reasons. So it's better to say, oh, I'm domiciled in Taiwan. That is much better. So if you have a problem, or for some reason people are reluctant to say this, openly, then cancel the domicile clause. Okay? So this is the best way. Again, very well, I've told the class, this is only, direction, non-legal binding. Okay? So these are the things that you need to remember. And when we move on, these are the examples to show what are the basic meaning in each of the 8 common clauses. Commencement clause. Commencement clause is to show that this is the beginning of a will. Just like in a Chinese will, you say Wai Zhou. And here, there is no short title, but the first clause is enough to show that this is the beginning of a will, in order to show that the testator knows what he is doing. He knows that he is making a will. Okay? So this is the commencement clause. So this is last will and testament of me, blah, blah, blah. Now, of course, you may say, can I just simply say this is my will? Or this is my last will? The answer is yes. Modern terminology. This is my will. This is my will, comma. Tag Wong, comma. I give everything to my wife and I appoint her as the sole executive. Full stop. This is perfectly okay. The only thing not okay is one, mix one with another, making a cocktail. Then beware of the terminology. Here, because it is tradition that we use last will and testament. They mean the same thing. Testament is something in connection with death, to take effect only when someone dies. So it's quite common to see this at the beginning clause. Revocation clause. Revocation clause revokes all previous will. So I revoke all former will, codicil, and other testamentary disposition. Again, it's a clumsy terminology. It is a clumsy terminology. But people use this description very often. Or for argument's sake, you can say, well, is there a difference in meaning of wills and codicil, Mr. Wong? Or other testamentary disposition? What are you talking about, Mr. Wong? A will is a will. So we dissect them into different phrases, so different parts and make it less meaningful. But this is how they use it in order to be all-inclusive. The law, by the Wills Ordinance, by definition, already include codicil. Codicil is just something like a supplement, or sometimes the layman term is a supplemental will. Okay, that's funny. Day 1, I make a will. Day 2, I make a codicil. Then if you're still awake, you will probably say, Mr. Wong, you just said codicil is a will. So if day one I make a will, day two I make a codicil, doesn't mean that day two will revoke the day one will? Yes. Because they are their wills by definition. But the unique feature is the day one will is a more comprehensive paper with all the common clauses that we have described. And then a codicil is not the whole will, but simply addition of small clauses or amendment of small clauses. Usually, for example, I make a will, I give everything to my wife, and then blah, blah, blah. And then day two, I make a codicil. I say, I give my car to my son. So that is a codicil, because it only provides certain testamentary disposition to supplement the will. So when I die, day one will plus the day two codicil will become the last will of that one. This is particularly the situation in England. In England, you have a will at day one, and then there may be day two, day three, day four, day five. So many codicils. This is my first codicil. This is my second codicil. This is my third, fourth, so on and so forth. This is how they would do it. Day one, I make a will. I give everything to my son. Day two, I make a codicil. I give my silver spoon to my sister. Day three, I give my small coins to my aunt. And then day four, I give my china, the porcelain, to my next door neighbor. This is what they do in the UK. Because in the UK, making a will does not mean that you need to go to a lawyer. You don't spend a dime. You don't spend any money. In the UK, everyone speaks English. Everyone can get something online without paying for it. So making a will just like making a clothes by themselves. So this evening, I think this is good. Okay, I'll give you a golden coin. Next time, I like to give you a silver spoon. All this small item, they just is endless. So they just do it like this. It's a matter of cultural habit. In Hong Kong, the situation is a little bit different. My advice, do not do codicil. Day one, you make a will. Day two, your client comes to you. Mr. Wong, I want to make a codicil. I want to give a silver spoon to my son. Then you can consider and giving away. Why don't you make a new will? It's cheaper. Okay? In a new will, you have a residual gift clause, and then the silver spoon will come in as a non-residual gift clause. Then you revoke the previous will, and you make a new will, and then day 3, day 4, day 5, no codicils. All new wills. For you, it's just change the non-residual gift clause. That will do. That is so much better, instead of using the way that they do in the UK about different codicils. So in Hong Kong, as a matter of practice, codicil, very uncommon. Very uncommon. In the Tang case, TAN, the Tang case, which is one case, don't need to worry. This is a case of a joint will. It's the only case that I've seen a joint will with a joint codicil. What it means is just like this. A joint will is a will of more than one testator. Okay? So in fact, there are two wills. One by the husband, the other by the wife. Appearing in one document. Okay? So this is called joint will. And usually it doesn't come in as part 1, will of husband, part 2, will of wife. No, they do not come in like this. They usually come in like this. We, instead of husband or wife, they say we when we die, we want to give everything to my son and my daughter, blah, blah, blah. So this is in fact only one will with a plural testatus. And then because the will that disposes of assets of one testator, so in this case, husband and wife, so we have a will containing in one document that represents the will of both the husband and the wife. So this is called a joint will. And then when the husband dies, the joint will be granted probate, applied for. And then when the wife subsequently dies, again you apply for another grant. So it's so complicated in terms of grant application. But in real life, I've seen it, and people make their own will. This is another example, free of charge. And then we love each other so much, we have consult with each other. So we say, we make our will. So fussy, and it's no good. If you have a chance to advise your client, you think, well, it's free of charge. You can do it yourself. You know, you're a university graduate, or even you are a lawyer yourself. Go online, download a will, one for yourself and one for your wife. Okay? Go free of charge. Don't make a joint will. There is problem of proving the grant on probate, and there is further problem if you want to change it. All this mutual will or joint will are problem area, very problematic. So for us, make a will with the clauses like this: one will for one man, or one will for one woman. Okay? You make another will, I give you a 20% discount. Okay? To encourage them to make sure to make more wills. Okay, don't make up your mind now, this evening, tomorrow come again. 30% discount, make another will. You have time and the chance to think about it more carefully, isn't it? Because the modern trend is people make many wills. Right? You have money and you have property. So this is the modern practice. And don't fall into the old habit of will and codicil and joint will and joint cod. So this will save our life. Before we move away, sometimes in dispute, you probably will have to ask, what is a will? A will, the gist of a will is on testamentary disposition. Okay? A will being a will is something to take effect only when the maker dies. So this is testamentary. And then a will being a will is to dispose of his property, his asset. So the unique function of a will being a will is it dispose of his own property, which will be considered when he died. So therefore, what we talk about a will is not the same thing as a will in Chinese when you call Wan Yin. This is complicated because sometimes in Hong Kong Wan Yin may mean a will. But a lot of time Wan Yin is not necessarily a will because it fails to satisfy the definition of a will, because in the document it may be testamentary, but it disposes of nothing. So since this is testamentary, but there is no disposal, therefore it is not a will for us to consider. And no grant will be issued. So you can see in recent history, particularly those politicians in China, Chinese politicians, they make all kinds of Wan Yin as something to encourage how the country can be further improved. So this is something that we have to be very careful. And then they will have more than one Wan Yin. Like for example, the will of Premium Chao En Lai. Well, there's only one small part that he gives, some asset to his wife. and the rest is for improvement of the country. And the same applies to Sun Yat-sen. When he died, well, his will was made by Ngô Dinh Huày, and there were 3 wills, which you can find online. Oh, how China can be further improved, when I die, when I pass away, and then what thing to be done, and how the country can be better ruled, blah blah blah. So all this just like presidential directions, except that technique for deliberation on the occasion of my death. So all this Huai Yin is not will. So, for our purposes, do not adhere to the request of your client to include in his will of his personal liking or disliking. Okay? Sometimes you'll find a will, I have decided not to give everything to my son. He's such a naughty boy. He has never respected me. He has run away with all the money and lived not having a good life with all kinds of females. By the same token, I don't give anything to my husband. He has been away. After we married, he never comes home every night. Or by the same token, you don't like your wife. Okay, I don't give everything to my wife because she never respect me. I give her nothing. So if you have instruction like this, you just reduce it into, I have considered the wish of my wife and I decided to give her nothing, or but $1. In order to satisfy 2 things. 1, the bank's a good fellow. Number 2, a will being a will is for disposition of one's asset. Another thing that also comes in is, a will is for disposition of one's own asset. So don't make your will disposing my asset. It happens. The husband will make a will, when I die, everything that belongs to my wife shall be given to my son. So this is basically wrong, because this is testamentary, this is disposition, but it's wrong in the sense it's disposition of somebody else. It's none of his business. He cannot dispose of somebody else's property unless he can allege all the property of my wife is in fact holding as registered owner for my beneficial ownership. Then it's a different story. Other than that, don't go wild. The last area that I need to draw your attention is on this revocation clause, particularly when there are limited wills. Make sure that the revocation clause is tailor-made to say this particular clause, this will shall revoke all previous will in relation only to the limited property as defined in this will. This is to remove the possible dispute later on when you die, to say that this revocation clause in the limited will in fact is intended to have a general effect. So disposition, limited. Revocation, unlimited. That is the problem. That the problem will be on your shoulder if you are careless. Once you come to make limited will, make sure that the revocation clause must be limited to the extent of property involved. Okay, so this is something to bear in mind. Appointment clause. Appointment clause can be complicated in the sense that there may be a different scenario that you have to pay attention to. Now, we'll stay until 9:40. Appointment, this is appointment clause. And then a lot of the problem occurs in a simple appointment clause like this because of this possible confusion on the terminology. As you can see here, I appoint blah 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 to be the executors and trustees of this my will. Now here, you call them my trustees. You have a choice. You can simply appoint Mr. A as the executor or sole executor without appointing him as the executor and trustees. In general, we do adopt this, but you will have to be very careful to know the distinction. Executor duties and rights is on administration of assets. Usually collect assets, convert them into cash, and then distribution. That is administration of estate in the general sense. Trustee does not arise in this sense, except that trustee, by definition in trustee, also include, in the trustee ordinance, cap 29, also include personal representative. But there is a fine line of difference. Trustee only arise normally after administration of estate. It will arise like this. In my will, I give everything to my son. I collect the asset, I pay the debts, then I distribute the estate to my son. But my son, when everything is ready, my son was only age under 18. He's age under 18, no legal capacity to sign the receipt, so I will have to hold on until my son attains the age of 18, when I can then distribute the residual estate in his favor. But everything is done, he's only 9-year-old. When that time comes, administration completed, but distribution not yet taken place, this waiting period, I shall then turn myself in the capacity as trustee by law. So you appoint myself as executor and trustee. So this waiting period, I shall work as trustee. There are fine distinctions in law, particularly if I die before completion of administration of estate, or if I die after I completed my executorship, but waiting time until distribution. So this will call into a fine line as, do I need to apply for secondary grant? Or do I need only to appoint somebody as the succeeding trustee without the need of a fresh grant? So, if I can do it like this, the law says it is much better, particularly involving landed property. So during this waiting period, everything collected, every debt paid, but not yet distributed. So I can vest all the property by me as the executor to me as the trustee by an assent. That will change the capacity without any misconception. This is one way. And the same argument shall apply if in my will I shall give everything to my son conditional upon his attaining the age of 30 years. Okay? So this is again is the problem. There's a waiting time because he is now only 18. He may never reach 30. If he doesn't reach 30, he will not be able to get the asset. So all this will be on the part of the trustee to get instruction as to how the trust property is to be dealt with. So just just to conclude the topic this evening. Now, you may, for some simple will, just like in the universal legislation, I appoint my wife as an executor. We thought that is permitted by law. There is no law that you must appoint the person with two capacities, executors and trustees, although normally we do. But as I've explained to you, there are different legal implications. Which is better is up to you. But normally this is general stuff, then we'll do it. One more minute before I let you go. There is one huge problem on the appointment clause. This example, I appoint A and I appoint B as executors. The Law Society has followed the instruction from the judiciary, the probate registry. If you appoint A and B to be the executors, this is valid. This is valid. But if you appoint A and B jointly as executors, again, this is valid, provided the grant will be applied by both A and B, not either or. In the first scenario, I appoint A and B here. Subsequently, A can apply for probate, B can apply for probate, A and B together can apply for probate. This is the legal effect. But if I say to appoint them jointly, add the word jointly, J-O-I-N-T-L-Y, then when it comes to probate, it has to be applied for by A and B together. What is even worse, which you should remember, never put wordings here as jointly or severally. Jointly, J-O-I-N-T-L-Y, or O-R, severally, S-E-V-E, S-E-V-E, several, V-E-R-A-L-L-Y. If you use wording jointly or severally, then this appointment is invalid. This is invalid. The probate registry has made this in the guide, and we in the Law Society has published a guideline. So remember, for the last this evening, never appoint someone, according to the present practice, never appoint A and B jointly or severally as to be executors. So this is a void appointment. Please remember carefully. Okay. Okay. That's I think that's enough for this evening.